But behind that conversation is a lot of education that they've had to get. And when you compare us to doctors who are doing surgery, all right, so where are we on this case?
Your Honor, we're here for two purposes now. The first one is we've subpoenaed some witnesses. We were trying to get to the bottom of some answers regarding the videotape. But before we go there, my client has asked me to let you know he wants to renew his request for a new attorney. So I told him I would let him address
I put in a motion.
All right, let me ask you this. Is your counsel hired or appointed?
Appointed.
All right, are you going to hire an attorney?
I'm trying to.
Well, I mean,
I asked him, it's because every time I ask him to do something, he does the exact opposite. I asked him back in September to please get me my bond reinstated so that I could bond out and pay for a lawyer. And he never did it.
All right, so let me explain something to you about the state of legal services, right? For some reason, attorneys, people think they can do an attorney's job, even though they didn't go to school to be an attorney. And the reason why I say this, listen, you have 2 ears. So listen, the reason why I say this is because people think that all attorneys do is talk, which we do. Attorneys do talk a lot. But behind that conversation is a lot of education that they've had to get. And when you compare us to doctors who are doing surgery, you never see a patient going to their doctor if they need heart surgery and telling their doctor, you know what, I know this is the way you say you're going to do the surgery, but I want you to do the incision this way. You know why they don't do that? Because, hey, I'm not a doctor. I don't know how to do incisions. But for some reason, people who have attorneys think that they're an attorney and they want to file a bunch of motions, don't know what the motions mean, because you may file one motion, but there are other things that go with that motion. It's sort of like when people read the Bible and they say, oh, I know the Bible, and they don't realize what you've read in the first book, there is something that goes with that that's in the second book, and you have to combine all of that. So if your attorney hasn't filed a motion, it's probably because you don't need that motion filed. I used to always get, you haven't filed my discovery motions. Where are my discovery motions? And I'm like, state has to turn that over. What? I'm filing a motion and the state is going to say, oh yeah, we turned that over. So that's where we are. And where we are is you're indigent. This is the attorney that has been appointed to you. And what I can tell you about attorneys appointed to represent people, there are certain qualifications that they have to have in order to represent people on certain cases. This is a felon in possession of a firearm. What I can tell you, your attorney is qualified to handle this type of case. Otherwise, he would not be appointed to this case. So if you wanted another attorney, you need to retain another attorney, period. Court is not appointing you another attorney. This will be your attorney. If you speak to him, great. If you don't speak to him, you will probably end up in jury trial with an attorney you have not spoken to. It's completely up to you. Do you understand?
Yes, ma'am.
And as a client, you have control over certain things, whether or not you want to go to a jury trial or not, whether or not you want to testify, whether or not you want to accept a plea. You are not in control of trial strategy. And trial strategy is similar to that doctor that wants to do a heart surgery and you're trying to tell them, well, this is the way you should do the heart surgery. That's similar to trial strategy. And you're not control over that because you don't have the degree and the experience to do it. Do you understand?
Yes, ma'am, I understand.
All right. So where are we?
Your Honor, we are back on a discovery issue. And just briefly to summarize, there was video and audio from the Alamo Heights Police Department. Originally, we asked for it and it said it didn't exist. Eventually, we subpoenaed Alamo Heights in. They were not able to answer the court's simple questions as to
yes,
when the video was destroyed, what is the policy? Are the videos 30 days, 60 days? I have anecdotal evidence that it's 6 months, but anyway, that's not on the record. So they gave us 4 names for Barcom. Barcom is a company, local company that is their IT company, as the point of contact who could answer all those questions. So I subpoenaed, but they couldn't tell us who there. So I subpoenaed everybody, and then they contacted me yesterday. They said, I don't want to cause any disruptions. I just want somebody, can you tell me if there's somebody there who can answer these questions? There isn't. They just sent somebody today by my, I had made an agreement with them to release everybody. They sent their CEO. He's here to testify. He's not going to be able to answer the court's questions. What he told me was, and he's back there.
Well, let's bring him up.
Yes.
Let's find out who can answer these questions. There are specific questions. I remember this case that are needed to be answered. Do you know who can answer these questions? Who do we need here to answer these questions?
The people who set it up, it's a company by the name of Big State. They are the ones who installed the camera system. They would have configured how long each of the cameras would overwrite, kind of like a VHS video, right? There's only so much space.
Yes.
And how often each one of those would be overwritten would have been set up by them. Our job is to, we're users of the camera system.
Yes.
We turn into the people that can go in and pull video, get the software on computers to access the video, but we don't manage it. It's a gray area, right?
Do you have information that you can impart to the state and defense about who they need to contact so we can find out, one, if the video was destroyed, two, when it would have been destroyed, and three, what is the time frame that videos are allowed to remain before it's purged or destroyed?
Okay, I don't like to use the word destroyed because destroyed implies purged is a much better word.
We'll use purge.
Yeah, we'll use purge because destroyed implies like.
See, whenever I think of purge, I think of the movie, so that's why I don't use it. But I understand about purging.
Yes.
Okay. So, do you have information of who would have that knowledge?
Here's what I'll do is I'll go back and I'll talk to our team now that we didn't get, first of all, we didn't get enough details, right? We're just asked a simple question. Well, I can go and see if we have access to figure out what the purging schedule is for each of the cameras. If I can get it, we'll get it directly to them. If not, we will point them, either way, we'll point them in the direction of the people who installed it and manage the system.
So what I want to know is, on this specific case, with this specific defendant, and they'll give you the date he was in the location. If you can tell me when that video or audio of him would have been purged.
Okay, we'll do our piece,
yes.
and then if we need to, we'll engage the third party.
All right. Is there any other question other than that you want answered? Because that's the question I want answered.
No, there's not. That's basically it. Judges, was there video? If so, why can't it be retrieved? Was it purged? And if it was purged, when it was purged? Because that answers the question of whether we should use the word purged or destroyed, which comes later. And that's.
Okay. All right. So they want to know. We'll use the word purge.
Okay, that's fair. No, I wasn't going there. If you don't mind, what we'll do is I'll go back and look at the dates. I don't know when the first request was, and then we have to work back from that date.
Before they leave here today, they're going to give you the dates when the defense counsel requested it.
Okay.
They're going to give you the date when he was in the facility, and then I want to know, one, is the audio or video still available? I'm sure it's not.
Right.
If it's not available, I want to know the date it was purged.
Okay.
All right. So how long do you think that will take?
A couple of days.
Okay.
I mean, from our part, unless we need to engage the third party, I don't have any control over how responsive they are.
I just want to keep this on the docket. So you saying a couple of days?
For my piece. If we can get the information, it'll be a couple of days. If we need to engage a third party, then it's a little out of my control unless we can get some of the some push from the court.
All right. So what we'll do, Norma, are we able to set this for December 14th? Is that enough time for your part?
Yes.
Yes, sir. All right. So what we'll do is we'll set it for December 14th.
Okay.
A plea of guilty on October 13th to the offense of possession with intent to deliver a controlled substance, penalty group 2. 4 to 400 grams. According to the agreement, punishment is to be assessed at 10 years in the prison. State opposes deferred adjudication. They're recommending community supervision, and there are some cases that have been taken in consideration. Have both parties had a chance to review the PSI report, State?
Yes, Your Honor.
Defense?
We have, Your Honor.
Any objections to the PSI report, State?
No, Your Honor.
Defense?
No objections, just a minor correction, Judge.
All right. Correction?
Just the represented that he was minimizing his guilt. I'm not sure exactly why. Then maybe they felt that way. Mr. Ayub didn't recall perhaps the baggies and the scales. That was quite really just an honest answer. He is accepting guilt. He pled guilty to this offense. He is prepared to accept the responsibility for that, Judge. And I just don't want the court to believe that he wasn't intending to take any responsibility for this.
Okay. All right, state, I'm sorry, any witnesses from either side?
No, Your Honor.
State you're opposed to the application for deferred adjudication?
Yes, Your Honor. I'm not sure. I know the defendant is asking for deferred. This is a first degree felony though, so if he does screw up on supervision, I feel like we're setting up failure if he does get the deferred, judge. So that's a long time he's looking at if he's unable to live up to the obligations of probation, judge. So that's the main reason I was opposed to deferred, judge. The other thing is these are a lot of charges that I know he's just pleading on the one, but we're taking into consideration several charges, judge. And the one he's pleading on is the possession with intent, but this is more of this is a drug dealing charge rather than a drug using charge. That's the reason for the opposition to defer, Your Honor.
All right, why should I give him deferred adjudication for dealing drugs?
Well, Judge, there are a number of things that I would like to address. He is taking responsibility for intent to deliver. There was a significant amount of pot-related items. I will just remind the court that it is THC-related items. He did use some for personal use. He's not denying the fact that there was times in the past where he has sold marijuana to people, but he had no intent that day. I think that's why maybe they thought he was minimizing his guilt. He was just going to enjoy his day with his girlfriend, got caught. He wasn't intending to sell anybody that day. I know it's a nuanced, Judge, but a lot of this was for personal use. His previous history, as you can tell, Judge, is cannabis related. The PSI indicates he has a cannabis dependence. I think he is clean now. I think he will continue to test clean, Judge, but they are all misdemeanors. He doesn't have any prior felonies, was never given a felony conviction, placed on felony supervision. I do understand that he picked these up over 2 different offense dates in short order. He really has no excuse for that other than he was making poor decisions. He wasn't taking in the grasp of what could happen to him should he get caught for this. He really just wants to apologize. And I would like him to give a short statement to you why he should be given deferred.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Theodore A.
All right, if you're drug tested today, what are the results going to be? And you will be drug tested today.
Negative, Your Honor.
All right, let's do a drug test.
Okay, Judge.
And then I'll come back and I'll make my decision.
Thank you, Judge. May I be excused shortly and I'll be right back
Sure.
as well.
Do you
Thank
need any water or anything?
Yes, ma'am.
All right.
He did use the restroom this morning, Judge. I was
Okay.
with him when he excused himself.
Sure.
Thank you, Judge.
All right. All right, were you able to provide a UA sample yet? Oh, there is a water fountain in the hallway. We'll get a cup of water for you. So we were here and I had asked for a UA to be done. Probation, was the UA done?
Negative, Your Honor.
Okay. All right. Is there anything else anyone would like to say?
Just briefly, Judge, I think
Sure.
his negative test shows that he is going to take this serious. State's argument that perhaps deferred would be setting him up for failure is a fair argument, but I don't think so for Mr. Ayub. I think showing that he's negative, he's taking this very seriously. He works hard. He helps his girlfriend take care of her children. He'd like to start his deferred, put this behind him, and hopefully there'll be a point in the future, Judge, where he can ask for early termination.
All right. Do you understand if I grant your application for deferred adjudication, if you are unsuccessful or a motion to revoke is filed, then the court could potentially sentence you up to life in prison
Yes, Your Honor.
and a $10,000 fine?
Yes, Your Honor.
Knowing that, are you still asking for deferred adjudication?
Yes, Your Honor.
All right. What do you do for a living, for employment?
Right now, I'm working for a demolition company,
And what are your hours?
usually from 7 a.m. till 3:30, sometimes 4:30. And sometimes I'll switch it from day shift to night shift, just depending on the job site.
All right. And the girlfriend that you're living with, who all lives in the household?
Me, her, and her 3 kids,
What are the ages of her 3 children?
15, 16, and 12.
Are these boys, girls?
2 boys and 1 girl.
And how long have you known her before you moved in with her?
About 2 years.
Sorry, just a second.
There's one more thing in the PSI, if I could address, if the court
Yes.
will allow me.
Sure.
They referenced that there was restitution for the testing of the drugs. In
Mhm.
one instance, they say that the restitution cost was $6,321. In the other instance, they're saying it was $1,254. I've never experienced those types of numbers when it comes to restitution for drug testing. I don't.
All right, State, do you know how much the restitution is?
Judge,
Those are wide ranges.
It is listed in the PSI specifically, Judge. It just doesn't itemize how, not that they need to itemize it, it's just a huge amount.
I'm not sure why it's that amount, Judge. I know typically we just do $57 to SAP or ECSO. Depending on which of the investigating agencies it is.
These were both out of the Bear County Forensic Science.
Right, so what we're going to do is, because the nature of the drugs, who knows, maybe they had to run some different tests. I'm going to order restitution, but we'll have a restitution hearing,
Okay, Judge.
and Ms. Ferguson will give us a date on that. Just give me a moment. Are you on GPS or anything of that nature, or no?
Sorry.
Are you on GPS or anything?
No, ma'am.
Right.
I do seem to remember, Judge, for the restitution. I think that's maybe why it's so expensive. I think it's expensive to test marijuana now with the changes in the laws the past few years. I think there's a special machine. And
It may be, Judge. I just had never seen those amounts. I appreciate you allowing us to have a restitution hearing. If in the meantime,
Yeah.
there's some justification for that, certainly
Yeah.
Mr. Ayu would be paying.
All right. We'll have a restitution hearing in regards to that. And State, how long do you anticipate it will take to get your witness? Is there going to be an objection for the witness by Zoom?
No, Your Honor.
Okay. So, and the witness can appear by Zoom.
yes, ma'am.
And if you will get with the Bear County Lab and see, maybe they have an itemized accounting for the amount.
And it's very possible Hank may get me that, Judge, and I'll say, oh, okay, that makes sense, and we won't need a restitution hearing. But thank you for giving this opportunity. If we don't need it, I'll inform the court.
All right. There'll be a $500 fine that will be probated. Does anyone wish to speak to the length of the deferred adjudication?
Judge, while the underlying term was 10 years over 10, typically the court, if it is inclined to grant deferred, I know that they tend to grant that similar term. If the state doesn't object, I would welcome a much shorter term for my client.
Well, what term would you be asking for?
Judge, I would leave that up to the discretion of the court. I think if Mr. Ayub is going to mess up, he will do like everybody else, and he messes up fairly early on in their supervision. So 5 years is a pretty long time, Judge. He's in his late 20s, and that's about 20% of his lifetime.
And Judge, I'm right in the middle of doing the TIC for the dismissal forms right now for the judges or for the causes that were taken into consideration in exchange for this plea, Judge. So the state is respectfully asking for the 10 years if you are inclined to grant deferred.
All right. All right. $500 fine probated, concurrent with County Court Cause number 688261. 9 years deferred adjudication. There's to be regular reporting by Zoom or in person. Random regular UAs. I would say that you could do the patch, but usually on the sites where you're working, since it's demolition, sometimes patches don't adhere very well. But if he wants, we can start off with the patch. And the patches cost more, but it has less time constraints because you just put it on. You don't take it off. I'm sorry, not you put it on. Probation will put it on, and then probation will tell you when it needs to be removed. But when they say it needs to be removed, you need to be specifically there at that time to have it removed. Do you understand?
Yes, Your Honor.
So which would you prefer?
In my understanding, Judge, is the patch alleviates him needing to come in person frequently for testing. Is that
Yes.
the trade-off?
Yes.
Let me see.
However,
Let's do the patch, Judge. That'll allow him to work and he won't have to miss work.
All right. I'll say random probation. I'm going to say random regular UAs or the patch, and they'll discuss with you how much the patch costs because it does cost more.
okay.
200 hours of community service restitution. 150 of those hours will be waived once you complete parenting classes. I'm going to order parenting classes. The remaining hours, they can be paid off to the San Antonio Food Bank at $7.25 per hour, or you can just do the community service hours.
Yes, Your Honor. Thank you.
All right, we're off the record. Mr. Ayub, you have decided to date someone who has children, and you are supposed to be someone in their life that they can respect and someone that they can look up to. By doing this, you're not being that person. You're not being a good stepfather if that's what you hope to be in their life. You understand?
Yes, Judge.
You're going to have to do better. All right. Good luck to you.
Thank you, Judge.
You're welcome.